this wonderful school in New York State. Thank you for allowing us to be with you and for you to be with us. In Jesus' name, amen.
As a parent of the state of New York, I am suing the public schools on behalf of my child because the law requiring a Pledge of Allegiance and a non-denominational prayer violates the Establishment Clause of the First Amendment, as made applicable to the states through the Due Process Clause of the 14th Amendment.
After filing a complaint, the Engel family took the state law to the state court, where the courts found in favor of the law, stating it was constitutional and was not in contrast of the Establishment Clause of the First Amendment nor due process of the 14th Amendment.
As a parent in the state of New York, we do not agree with the decision of the state, so we demand a writ of certiorari.
Petitioner parents requested a writ of certiorari on the judgment of the State Court of Appeals rendered for Respondent Board of Education and upholding the order from the lower state courts allowing respondents authority to use prayer in public schools so long as no pupil was required to pray and if his parents refused permission.
Here is the law clerk to read the appeal.
The court held that the respondent's use of the prayer in its school system breached the constitutional law of separation between church and state. Now, here is the Solicitor General on behalf of the public school system in the state of New York.
On behalf of New York Public Schools, we would like to say that this law does not go against the Establishment Clause of the First Amendment, stating that the government is prohibited from making any laws respecting an establishment of religion. This clause not only forbids the government from establishing an official religion, but also prohibits government actions that utterly favor one religion over another, nor does it go against due process of the 14th Amendment, stating no person shall be deprived of life, liberty, property. In our law, no person is required to participate in this prayer, and no religion is favored in the school system.
Now, for the amicus curiae brief.
On behalf of the residents of the state of New York, we believe this law is in fact unconstitutional. It goes against the Establishment Clause of the First Amendment. It favors the Christian religion, and in fact, it zeroes in on the non-denominational views of this religion. It also goes against the due process of the 14th Amendment. Although it does say kids are not required to participate in this prayer, it makes the kids feel uncomfortable and obligated to participate in this prayer, to not be frowned upon in the classroom.
And the last two arguments have been a part of the oral arguments. After hearing the arguments, the judges will convene in their conference. Justice Douglas has the concurring opinion, saying,
My view of the Establishment Clause argues that any type of public promotion of religion, including giving financial aid to religious schools, violates the Establishment Clause.
Justice Stewart, however, had the dissenting opinion, stating,
I argue that the Establishment Clause was only meant to prohibit the establishment of a state-sponsored church, such as the Church of England, and not prohibit all types of government involvement with religion. In particular, I find that the non-denominational nature of prayer and the absentee provision removed constitutional challenges.
This was the final decision of the court.
The court held that the respondent's decision to use its school system to facilitate recitation of the official prayer violated the Establishment Clause. Specifically, the policy breached the constitutional wall of separation between church and state. The court ruled that the constitutional prohibition of laws establishing religion meant that the government had no business drafting formal prayers for any segment of its population to repeat in any government-sponsored religious program. The court held that the respondent's provision of the contested daily prayer was inconsistent with the Establishment Clause.
The Supreme Court ruled the New York state law unconstitutional.
leading to Engel winning the case.
This is a landmark case because it clearly defined the separation of church and state for all future cases.
Goodbye. I hope you enjoyed the show.
Deuces.
Justice Stewart have the state, so we demand a writ of.
On behalf of Nelson.
Okay.
We just don't get along.
All right.